Hello and welcome. My name is Mason Rashtian, and I'm the founder of the Mason Law Firm here in California. First, I'd like to thank you for taking the time to watch this webinar. I sincerely hope you never need the information we're about to discuss. But if you or someone you care about is ever involved in a car accident, what you do during the first few minutes, the first few days, and the first few weeks can have a significant impact on your health, your recovery, and your legal rights. Most people have never been through a serious car accident. So when they are, they're suddenly dealing with injuries, vehicle damage, insurance companies, medical appointments, lost wages, and a lot of uncertainty. It's completely understandable to feel overwhelmed, and that's exactly why I created this webinar. But first, why should you listen to me? I've been practicing law in California for nearly 3 decades. Earlier in my career, I represented insurance companies. Today, I exclusively represent people who have been injured because of someone else's negligence. That means I've had the opportunity to see personal injury claims from both sides. I've seen how insurance companies investigate claims. I've seen the mistakes that can weaken otherwise valid cases. And I've also seen the simple steps that can make a tremendous difference in protecting someone's rights after an accident. My goal today isn't to scare you, it's to educate you, because informed people make better decisions. During this webinar, we're going to walk through the entire process that follows a motor vehicle collision. We'll discuss what to do immediately after the accident, how to collect important information, what photographs you should take before leaving the scene, common mistakes people make when dealing with insurance companies, medical authorization forms, recorded statements, why timely medical treatment is so important, how gaps in treatment can affect your claim, and the dangers of social media while your case is pending. My goal is to provide practical information that you can actually use. Whether you ever hire an attorney or not, I want you to leave this webinar with a better understanding of how to protect yourself after an accident. Before we begin, I want to make one important point. Every accident is different. Every injury is different. Every client is different. And every case has its own unique facts. The information I'm sharing today is intended to provide general educational guidelines based on California law. It isn't legal advice for your specific situation, and it shouldn't replace advice from your physician or an attorney who has the opportunity to evaluate your individual circumstances. If you're ever unsure about what to do after an accident, don't guess, ask questions. Getting accurate information early can help you avoid costly mistakes later. So with that, let's begin with the most important question of all. What should you do immediately after a car accident? Over the years, I've represented thousands of injured clients throughout California. One thing I've learned is that many people don't make mistakes because they're careless. They make mistakes because no one ever taught them what to do after an accident. My goal today is to change that. Let's begin with what happens immediately after an accident. Whether you've been involved in a car crash, motorcycle accident, bicycle accident, or hit as a pedestrian, the decisions you make during the first few hours can have significant impact on your health and later on your personal injury claim. Many people panic because they've never been involved in an accident before. Others assume everything will be okay and work out by itself. Then some simply want to get home as fast as possible because they're just stressed. Unfortunately, these natural reactions can sometimes make it much more difficult to prove what happened or demonstrate the extent of your injuries. Here are the steps I recommend. Your first priority is always safety. If you're physically able, check yourself first. Then check on your passengers and everyone else involved. If it's safe to do so, move your vehicle out of traffic to prevent another collision. Turn on your hazard lights, and if anyone appears to be injured or you're simply not sure, call 911. Remember, adrenaline can mask pain. It's common for people to say, I'm fine, only to discover hours later that they've suffered significant injuries. So don't assume that because you can walk away from the accident, you're not injured. One of the most significant things you can do following an accident is to call law enforcement if appropriate. So, depending on where it happens, you may have to call the police. For example, in Los Angeles, it would be the Los Angeles Police Department, LAPD. If you're in the Santa Clarita area, it would be the County Sheriff Department. If you're on the highway or the freeway, clearly it's the California Highway Patrol or the CHP. A report can become one of the most important pieces of evidence in your case if liability becomes an issue. When speaking with an investigating officer, simply tell the truth and stick to the facts. Avoid saying things such as, I guess I didn't see him, or maybe I was going a little fast. So never discuss how fast you were traveling. That's an important issue. If you don't know something, it's perfectly acceptable to say, I am not sure. Speculation has a way of finding its way into reports and can later be used against you by an insurance company or a very good defense attorney. Part of documenting the evidence is to take photographs of the vehicles and of the scene of the accident. Take photographs of the other vehicle and take photographs of your vehicle as they stand at the accident scene. It is very important that you take photographs of the other vehicle because this may be the only chance you get to take those photographs, because you can always take photographs of your own vehicle later on. If liability is going to be contested, for example, the accident happened at an intersection, make sure you get the scene of the accident from various angles. You also want to take photographs of any skid marks or lack of skid marks and any road conditions that may have caused or contributed to the accident. If signals and road signs such as yield or stop signs become important, make sure you have those in the photographs as well. Just remember, the more photographs you take at this point, the better. You can always delete photographs later on. You should always be mindful, however, if your vehicle has no visible damage, that if you take photographs of your vehicle, you may have to produce those later on if there's a lawsuit filed, and that could potentially hurt your case. But obviously, if damage is extensive, you definitely want to photograph your vehicle from every angle that's possible. While at the scene of an accident, if an independent witness stops by to either help or you notice that they observed the accident, politely ask for their name and contact information. This could be crucial in cases where liability becomes an issue. For example, it's an intersection accident when one party enters the intersection on a red light while the other one enters into a green light, and it becomes a he says versus she said scenario. If an independent witness saw who entered the intersection on a green light, that will substantiate who caused the accident. If you don't get that person's information at the scene, you will almost always not be able to locate that person again. So it's important to get an independent witness to verify what happened if liability is going to be an issue. So you may be wondering, should I talk to the other driver's insurance company after an accident? The general advice is no until you talk to a personal injury attorney. Here's what happens after an accident. You're going to get a call from the other driver's insurance company, and the adjuster is going to be very nice to you, and they're going to ask you certain things. One of them is about your property damage, right? As far as how damaged is your car. Uh, One of them is going to be about the facts of loss, how the accident happened, and the other one is going to be your injuries. So, if you get stuck talking to an adjuster before consulting with a personal injury lawyer, best advice is to only discuss your property damage, such as where to take your car to get repaired, or if the car is totaled, the car is located. Does it have to be towed from a tow yard or from your house? And about replacement cost. Do not talk about the accident itself. You can simply tell them, I don't want to talk about the facts of the loss until I talk to my attorney, and never ever discuss anything about your injuries. The worst thing you can say to them is, I feel fine today, because if you do, they're going to use that against you later on when you make an injury claim. So, when it comes to the injury portion of it, if you have not gone to urgent care or seen a primary care doctor or start treatment with somebody, best thing to do is just say, I don't feel fine. I need to get checked out by a healthcare provider. Until I get checked out, I do not want to answer any questions about my injury. Avoid talking about the injury, period. Only talk about your property damage. If you end up speaking with an insurance adjuster, one of the things that they will ask you to do is to fill out some forms in order to process your claim. One of those forms is frequently a medical authorization. Now, it may seem harmless, but it's not. A medical authorization is a document that allows someone else, such as an insurance adjuster, to obtain your medical records. Many people assume that insurance companies simply want these records related to the accident, but that is not always the case. Most authorization forms are written very broadly, and by signing them, you're allowing the insurance company permission to obtain all of your medical records from previous years and even decades, which they're not entitled to do. Many of these records are completely not related to the accident. Now, you may be wondering why an insurance company would want your medical records. Well, they're not doing it because they're curious. They're looking for evidence they can use to either reduce or deny your claim. For example, they may be looking for previous neck pain, prior back injuries, earlier car accidents, arthritis or degenerative changes, sports injuries, prior workers' compensation claims, any medical condition they can use as an argument to show that your injuries in this accident are not related to this accident, but to something different. If they find something, they will use that against you. Are you required to sign such documents? No. In personal injury claims, you're not required to sign the insurance company's medical authorization. Now, this doesn't mean that they're not entitled to relevant medical records. So if you're claiming injuries to your neck, back, shoulder, or another body part, records relating to those injuries may ultimately need to be produced. But there's a big difference between providing relevant records and giving the insurance company unrestricted access to your entire medical history. So instead of signing blanket authorization, your attorney can obtain the appropriate medical records directly from your healthcare providers. Those records can then be reviewed before they're provided to the insurance company. This helps ensure that only records relevant to your claim are produced and confidential or unrelated medical information isn't disclosed unnecessarily. It also allows your attorney to identify issues that may need to be addressed, such as pre-existing conditions that were aggravated by the accident. Medical authorizations aren't the only forms you should be careful of. Insurance companies may also want you to sign employment authorizations, wage authorizations, property damage releases, settlement releases, or any documents that they describe as routine. Never assume a document is harmless simply because the adjuster says it is. Read every document carefully. If you have any questions, ask an attorney before signing. Once you've signed certain documents, it may be difficult or even impossible to undo the consequences. Now, having represented both insurance companies and injured people over the course of my career, I've seen these authorizations requests from both sides. Insurance companies routinely investigate claims, and part of those process includes reviewing medical history that may be relevant to the injuries being claimed. However, as someone representing an injured person, it's important to make sure that only appropriate, relevant information is disclosed. So my advice is simple. Don't sign authorization forms simply because an adjuster asks you to do so. Understand what you're signing. If you're not sure, seek legal advice before you give anyone access to your medical records. And protecting your privacy at the beginning of a claim can help prevent unnecessary disputes later. Now that we've talked about dealing with the insurance company, let's discuss another mistake that I see time and time again. That is giving a recorded statement to the other driver's insurance company. Many people don't realize that what they say during a conversation can have lasting impact on their claim. Let's talk about something that happens in almost every personal injury claim. You may have already spoken with the adjuster about repairing your car and setting up a rental, but the subject of a recorded statement didn't come up the first time. Remember that the adjuster needs your permission in order to record any conversation about the incident. So you may get a friendly call from the adjuster. This may have happened during your first conversation with the adjuster, but if not, it may occur in a separate conversation. The adjuster will be polite, and sooner or later, the adjuster will say something like, "We just need a quick recorded statement so we can process your claim." Many people think, "I have nothing to hide, so why not?" In most situations, I recommend that you do not give a recorded statement to the other driver's insurance company without first speaking to an attorney. So why does the insurance company want a recorded statement from you? People often assume the adjuster is simply trying to understand what happened. But that's only part of the picture. Insurance companies investigate claims because they have to determine liability and evaluate damages. A recorded statement can become part of that investigation. The adjuster is trained to ask you detailed questions about how the accident happened, what you saw before the accident and after the accident, what you and the other driver or drivers discussed after the accident, what you didn't see about your injuries, what are your medical history, your activities before and after the accident, any prior accidents, and any prior claims. Every answer you give becomes part of the claim file. And because the conversation is recorded, it can be replayed later if there's a dispute about what you said. Now, when it comes to liability issue, if the accident is going to be contested, for example, it's a red light dispute between you and the other driver, this will definitely be an issue because they will want to know when you first saw the other vehicle, what was your speed, what was the traffic signals, how far were you from the intersection. Whole lot of questions that come into play that you need to be aware of before you talk to an insurance adjuster. Now, when it comes to the injury portion of it, what people don't understand and appreciate is that you're giving the recorded statement very early on in the claim. Sometimes it could be the same day as the accident. At that point, you probably don't know the full extent of your injuries. You don't know whether you'll need physical therapy or chiropractic treatment. You don't know if you'll need an MRI. You don't know whether you're going to be missing work because of the accident. You won't even know if you eventually require surgery. Yet the adjuster may ask questions such as, "Are you feeling okay today? Are you injured? Is there anything else bothering you?" Most people answer honestly based on what they know at that moment. The problem is that injuries often evolve over time. So, what may seem like a minor soreness today may become a diagnosed disc injury several weeks later. But by then, you've already given a recorded statement to an adjuster without first talking to an attorney, and that could be used against you later on. Even small statements can be very important later. For example, saying, "I'm okay. I just feel a little sore today. I don't think I'm hurt." Those may simply reflect how you felt immediately after the collision. But days later, weeks later, months later, if your symptoms worsened, those early statements may be compared to your later medical records and your claims of injury. Now, that doesn't mean your injuries aren't real. It simply means spoken words before you fully understand your condition may later become part of the discussion. Another thing I've learned over nearly 3 decades is that adjusters are very good at making conversations feel informal. So they could be asking you, "What were you doing that day? Where were you going? How fast were you driving? When did you first see the other car? What could you have done differently? Who do you think was at fault for the accident and why?" Each of these questions may seem harmless by themselves, but together they help the insurance company evaluate fault and compare your answers to the police report, photographs, witness statements, vehicle damage, and other evidence. In a personal injury case, consistency matters. So, can the insurance company require you to give a recorded statement? If you're dealing with the other driver's insurance company, the answer is often no. Their insured has a contractual obligation to cooperate with the investigation. But that is not you because you're not their insured. So you generally do not have the same contractual obligation. There may be exceptions depending on the type of claim. And if you're making a claim under your own insurance policy, such as an uninsured or underinsured motorist claim, your own policy may require you to cooperate with your insurer's investigation, and that would require giving a statement. That's one reason it's important to understand which insurance company is requesting the statement and why. So, what should you do in case the adjuster asks for a recorded statement? If the other driver's insurance company asks for a recorded statement, don't feel pressured to answer immediately. You can politely say, "I'd like some time to consider your request," or "I'd like to speak with an attorney before giving a recorded statement." Those are perfectly reasonable responses. If you decide to hire an attorney, the attorney can communicate with the insurance company on your behalf and advise you about whether a recorded statement is appropriate under the circumstances. So here's a perspective from both sides of litigation. Early in my career, I represented insurance companies. Today, I represent injured people. Having worked on both sides, I understand why recorded statements are requested and how they're used during the claims process. I've also seen how innocent mistakes can create unnecessary issues later on in a case. That's why I encourage people to slow down, understand what they're being asked to do, and make informed decisions before participating in a recorded interview. Knowledge is one of the best ways to protect yourself after an accident. Now let's move on to another issue that surprises many people after an accident. That is why you should seek medical attention promptly, even if you think your injuries are minor. Delaying treatment can affect both your recovery and how your claim is evaluated. Let's talk about one of the biggest mistakes I see after an accident. People wait too long to seek medical treatment. Sometimes they'll think, "I'm just sore, it'll go away." Others don't want to miss work. Some are worried about medical bills, and many simply believe they'll feel better in a day or two. Sometimes that's exactly what happens, but sometimes it doesn't. One thing I've learned after nearly 3 decades handling personal injury cases is that not every injury appears immediately. Immediately after a collision, your body releases adrenaline and other stress hormones. These chemicals are designed to help you survive a traumatic event, so they can temporarily mask pain. It's not unusual for someone to walk away from an accident feeling relatively okay, only to wake up the next morning with severe neck pain, back pain, headaches, and stiffness. I've represented many clients who felt fine at the scene but developed significant symptoms over the next few days. That's why it's important to pay close attention to how your body feels after an accident. Remember, some injuries develop over time, and not all injuries are obvious right away. Those include soft tissue injuries, whiplash injuries, concussions, disc injuries, ligament injuries, muscle strains. These conditions often become more noticeable over the first few days as inflammation develops. Don't assume you're uninjured simply because you didn't feel immediate pain. If symptoms develop, don't ignore them. Have them evaluated by a qualified medical professional. And remember, after an accident, you want to ice the locations that you may feel pain. Do not use heat in the beginning, because heat will only add to the inflammation, while ice reduces inflammation. There are two main reasons why you should seek medical attention promptly. First, and by far the most important one, is your health. The sooner an injury is properly diagnosed, the sooner appropriate treatment can begin. Early treatment can help reduce pain, improve recovery, and identify more serious injuries before they become worse. The second reason involves your personal injury claim. Medical records create a timeline. When your symptoms are documented shortly after the accident, those records help establish when the symptoms began and how they progressed. Insurance companies review medical records very carefully. If someone waits several weeks before seeing a doctor, the adjuster may naturally ask, if the accident caused these injuries, why didn't you seek treatment sooner? That doesn't necessarily mean the claim is invalid. There are many legitimate reasons people delay treatment, but a delay can become an issue that may need to be explained. The closer your medical treatment is to the accident, the easier it generally is to establish that timeline. Now, just as important as starting treatment is continuing your treatment. One of the issues I frequently see is gap in medical care. A person treats for several weeks, then they stop. Several months later, they return because the pain had gotten worse. When that happens, insurance companies often ask questions such as, what happened during those months? Did something else cause the pain? Were the injuries really serious if treatment stopped? Again, that doesn't mean the claim is lost. Sometimes there are perfectly reasonable explanations. Perhaps the person couldn't get an appointment. Perhaps insurance issues delayed treatment. Perhaps work or family responsibilities got in the way. But whatever there is a significant gap, it's important to be prepared to explain it honestly. You also need to follow your doctor's recommendations. If your physician recommends physical therapy, go. If they recommend follow-up appointments, keep them. If they recommend diagnostic testing such as an MRI, discuss it with your doctor and understand why it's being recommended. Your treatment should always be based on your medical needs, not your legal claim. Following your doctor's recommendations demonstrates that you've taken recovery seriously. When you see your healthcare provider, be honest. Don't exaggerate your symptoms. But don't minimize them either. Tell your doctor where you hurt, when it hurts, what activities make it worse, whether you're having headaches, dizziness, numbness, tingling, difficulty sleeping, trouble walking, problems caring for your family, or difficulty enjoying hobbies or daily activities. The more, the more accurate the medical history, the better your healthcare providers can diagnose and treat your injuries. Many people expect to feel completely better within a week or two. Unfortunately, that's not always realistic. Recovery is different for everyone. While some injuries heal quickly, others require months of treatment. Some people recover completely, while others continue to experience intermittent pain long after the accident. Your goal shouldn't be to rush through treatment. Your goal should be to recover as fully as possible. Having represented both insurance companies and injured drivers, I've seen how important the medical records become in every personal injury case. Good medical records don't just document treatment, they tell the story of your recovery. They explain when symptoms began, how they changed over time, what treatment was necessary, and how the injuries affected your daily life. That's why I encourage people to seek appropriate medical care when symptoms develop and to follow through with their treatment plan. Your health should always come first. Now that we discussed medical treatment, let's talk about another mistake that can seriously affect a personal injury claim. That is posting about your accident or your injuries on social media. What you post online can sometimes be used in ways you never expected. So let's talk about something that surprises many after an accident. That is social media. Facebook, Instagram, TikTok, X, Snapchat, LinkedIn. Even if your account is set to private, you should assume that anything you post online can eventually be seen by others. Many people don't realize that social media posts can become part of a personal injury claim. After an accident, insurance companies investigate claims. That investigation may include reviewing publicly available information, including social media accounts. They're looking for anything that appears inconsistent with the injuries you're claiming. Sometimes it's obvious, sometimes it's completely innocent. The issue isn't necessarily what you meant by the post. The issue is how someone else may interpret it months later. Here's an example. Let's say you're recovering from a neck injury. A few weeks after the accident, your family convinces you to attend your daughter's birthday party. You smile for one photograph. That picture gets posted on Facebook. Months later, the insurance company points to that photograph and says, "She doesn't look injured." What they don't see is what you stayed for only 30 minutes, or that you spent the next 2 days in pain, or that you left early because your neck and back were hurting. A single photograph rarely tells the complete story. And it's not just what you post, it's what your friends and family post as well. Some may tag you in a picture. They may post a video. They may check in at a location. They may write, "Looks like you're having a great time." Even though you meant nothing by it, the post can create questions later. For that reason, I recommend asking friends and family not to tag you in social media posts while your claim is pending. Another mistake I see people posting about is the accident itself. They write things like, "The accident wasn't my fault. I'm going to sue. The insurance company is offering me peanuts." Or they start discussing their injuries online. Avoid doing that. If your case eventually ends up in litigation, those posts may be reviewed and compared with your testimony, your medical records, and other evidence. Your case should be built on the evidence, not on social media posts made in frustration or emotion. People would often tell me, but my account is private. That's certainly better than having a completely public account, but private doesn't necessarily mean invisible. Information can be shared, screenshots can be taken, posts can be forwarded, privacy settings can change. The safest approach is simple. If you won't be comfortable seeing it displayed in a courtroom, don't post it while your case is pending. Now I have to make something very clear. I'm not suggesting that you should stop living your life. If your doctor says it's appropriate to attend family gatherings, go. If you can celebrate a birthday, celebrate it. If you can enjoy time with your children, absolutely do that. The point isn't to isolate yourself. The point is to be thoughtful about what gets posted online when your claim is ongoing. Here's the rule I give to clients. Before posting anything, ask yourself one question. Could someone who doesn't know the full story misunderstand this? If the answer is yes, don't post it. At least not until your case is resolved. Over the years, I've seen social media become an increasingly common part of personal injury cases. Sometimes the posts don't matter at all. Sometimes they become a major issue. And almost always, they're avoidable. The easiest way to prevent misunderstanding is to simply be cautious about what you share online until your claim has been completed. Protecting your case doesn't mean hiding the truth. It means making sure your story is told through the evidence, your medical records, and the facts, not through a photograph or social media post that lacks content. Now that we've covered social media, let's talk about another question I hear all the time. How long is my case going to take? Understanding that timeline of a personal injury claim can help you set realistic expectations and avoid one of the biggest mistakes people make, trying to settle too early. Before evaluating a settlement, you should have a reasonable, clear understanding of your injuries. Questions that often need to be answered include: have you completed your treatment? Are you still improving or recovering? Will you need future care? Do you have permanent limitations? Will you require surgery? Will your injuries affect your ability to work? Will they affect your daily activities in the future? Until those questions are answered, it is often difficult to accurately determine the value of a claim. You may hear the term maximum medical improvement, or MMI. That doesn't necessarily mean you've completely recovered. It means your condition has stabilized enough that your doctors have a good understanding of your long-term prognosis. Sometimes you're fully recovered, sometimes you have permanent symptoms, sometimes future treatment is expected. Reaching that point gives someone a much better understanding of the true value of the case. Maximum medical improvement generally means that you've reached the most you can reach with the current treatment, and no additional treatment that is currently ongoing is going to help you. That doesn't mean surgery or future treatment may not help, but currently, based on what you were getting, you're not going to get any better, and with any additional treatment, time may be what you need to do to recover. Sometimes insurance companies make settlement offers very early in the process. That doesn't automatically mean they're acting unfairly. Sometimes they're simply trying to resolve a case efficiently. But before accepting any offer, you should ask this: do I really know how badly I'm injured yet? If the answer is no, it may be wise to wait until your medical condition becomes clearer. A settlement should compensate you for the injuries you actually sustained, not just the injuries you knew during the first week after the accident. So patience doesn't mean doing nothing. It means using the time wisely. Continue your medical treatment. Follow your doctor's recommendations. Document your recovery. Keep records of your medical expenses and lost income. As more information becomes available, your attorney can better evaluate your claim and negotiate from a position of knowledge rather than guesswork. Here's my perspective. After handling personal injury cases for nearly 3 decades, I've learned that rushing rarely benefits an injured person. Some of the best settlements I've obtained for clients happened because we took the time to understand the full extent of their injuries before entering serious settlement negotiations. Patience allows the evidence to develop, medical records become more complete, doctors can better evaluate future treatment needs, and both sides have a clear picture of the case. That usually leads to better informed settlement discussion. If there's one thing I hope you remember from this section, it's this. Don't let the calendar determine when you settle your case. Let the facts determine when you're ready. Your health comes first. Once you understand your injuries and future medical needs, you'll be in a much better position to evaluate any settlement offer. Before we wrap up, I'd like to leave you with a few final thoughts. If you've been involved in an accident, remember this. The decisions you make during the first few days and weeks can have a lasting impact on both your health and your legal rights. Most people have never been through a serious accident before. So they're dealing with pain, they're worried about their family, they're missing work, they're getting calls from the insurance company, and they're trying to make important decisions while under a tremendous amount of stress. That's why education is so important. The more you understand the process, the better prepared you'll be to protect yourself. If you remember nothing else from this webinar, I hope you'll remember 3 things. First, make safety your priority. Get medical attention whenever it's needed. Second, document everything. Take photographs, collect information, save receipts, keep copies of your medical records. Third, be careful when dealing with insurance companies. Understand what you're signing. Think carefully before giving recorded statements. Don't let anyone pressure you into making decisions before you're ready. Fourth, follow your doctor's recommendations. Your health should always come first. Finally, if you have questions, ask. Whether it's your doctor, your insurance company, or an attorney, don't guess. Good decisions are made with good information. One thing I'd like everyone watching to understand is this. You don't have to figure everything out by yourself. If you've been injured because of someone else's negligence, there are professionals who can help guide you through the process. Sometimes all it takes is a conversation. Even if you ultimately decide not to hire an attorney, understanding your rights can help you avoid costly mistakes. The goal isn't simply to resolve a legal claim. The goal is to help you recover physically, financially, and emotionally from something that hopefully you'll never have to experience again. Thank you for taking the time to watch this webinar. I hope the information I've shared helps you feel more prepared should you or someone you care about ever be involved in an accident. My name is Mason Rashtian, and I'm the founder of the Mason Law Firm. For nearly 3 decades, I've represented injured people through California, and before that, I've represented insurance companies. That experience has given me the opportunity to see personal injury claims from both sides of the table. My goal has always been simple: to educate people, answer their questions honestly, and help them make informed decisions. If you found this webinar helpful, I encourage you to explore other educational resources. You'll find educational videos, articles, podcasts, and guides on our website and social media channel covering many of the topics we discussed today. If you or someone you know has been injured in a car accident, slip and fall, dog bite, or another incident caused by someone else's negligence, we'd be happy to answer your questions. Contact the Mason Law Firm for a free consultation. We'll take the time to listen, explain your options, and help you understand the next steps. Thank you again for joining me today. I'm Mason Rashtian, and on behalf of everyone at the Mason Law Firm, I wish you good health, safe travels, and I hope you never need this information. But if you do, I hope you'll remember what you've learned today. At the Mason Law Firm, we've been our clients by accident.